So thank you for attending today's discussion titled Environmental Due Diligence, Scary Unknowns and Tricks or Treats. Our panelists are Mitch Wiest and Eric Allon. Eric Allon is a real estate and business law partner at Bernkopf, Goodman, LLP. Eric has been recognized as a thought leader in real estate, has written extensively, and has been a speaker and moderator on numerous panels, including a TED Talk style speaker at the Coronet Global Summit at the Heinz Auditorium. Eric was recognized as a top influencer by the commercial real estate publication Globe Street. Mitch Wiest is a principal with Roux and has been responsible for the design and oversight of hydrogeologic investigations and the cleanup of brownfield state voluntary state transfer programs, CERCLA, TSCA, and RECRA sites across the United States. Mitch is an active member of ASTM International as a voting member of the committee that oversees the development of Phase 1 and Phase 2 environmental site assessments, as well as the Connecticut licensed environmental professional community. And my name is Tanya Bissell, and I'll be the moderator today. Before we get started, I want to quickly review the format of today's live discussion. We've allotted 60 minutes for this panel discussion. We encourage comments and questions. Questions will be answered at the designated Q&A breaks throughout today's discussion. Please submit your questions by clicking on the Q&A icon located on the Zoom toolbar at the bottom of your screen. A quick thank you to those who submitted topics of interest and inquiries through the registration form. We appreciate your participation. Once again, thank you for your attendance. Now let me introduce Eric to take it from here. Eric?
Thank you, Tanya. Environmental due diligence. We're on the eve of Halloween, and it can be a very scary topic. We don't know sometimes what's under the slab, what's behind the walls, or what's coming at you from your neighbors. And sometimes it can be very costly to clean up those environmental problems. But for some, including some in our audience, it's an opportunity. If you can buy the property, you can repurpose it. You can put AULs, activity use limitations here in Massachusetts on it, and you can move forward and make some money. Mitch, I use the word AULs. You can repurpose some property. They're known as brownfields. Let us know. You talked to me about brownfields being big B and little b. And also, I wanted you to share some of your thoughts on AULs.
Hello to everyone, and thanks for joining, and thank you, Eric. So when I think about brownfield projects, I often discuss it with my clients as either a big B or a little b type of project. Now, the little b basically refers to any contaminated piece of property that may be underused or someone is seeking to repurpose it once it's cleaned up for a higher and better use. So that's pretty much the entire universe of impacted properties that may be candidate for real estate transactions. The big B, on the other hand, refers to sites that are eligible for all sorts of regulatory or government assistance. Many in the group here may be familiar with EPA grants which is basically money that the feds provide to states and local municipalities to investigate and sometimes clean up these underused properties. And there are also state programs that would fall under the big B, where they will actually provide cleanup grants, low interest or no interest loans in some cases, or tax credits for folks to come in and take these properties and clean them up. So big B refers to these little b sites which get assistance, monetary assistance, tax credit assistance from various regulatory agencies.
Mitch, let's start by looking under the slab and see what's there. Sometimes you think you know what you have, but you really don't know until you investigate a little further. You had an experience in Fairfield that you thought you knew the site, and then actually you learned some surprises. Please tell us about that.
Sure, thank you. This is a really interesting example about a site that was 100-year-old plus industrial facility that was expanded over the decades. I think the first building was somewhere in the 1910s, and the final building at the property was 1970s. And this facility was actually built in an old quarry. So much of the facility, much of the buildings of the facility were virtually on top of bedrock, maybe, 6 inches to a foot of soil at most under most of the facility. And as this facility was built out, new buildings were added. And finally, the most recent building was built in an area that would be closest to the current front road or frontage. When we were doing due diligence at the site, and this site has been the subject of all sorts of action, so it's been investigated for years before the reuse and transfer was considered. Depth to bedrock, like I said, was pretty shallow. And when we looked at the front of the facility, unfortunately, it was still an active facility, so we couldn't actually do much investigation from within, just around. And the few opportunities we had to drill inside encountered shallow refusals, and refusals is how we refer to when the drill rig can't get any deeper. The bit refuses to go deeper. And that refusal was, a foot or so below grade, below the top of slab, which was consistent with the bedrock elevation in the other portions of the site and in some of the driveways and roadways. And, the assumption based upon best available information that, what we found in the front was consistent with what we found in the back. Well, fast forward to when the building's coming down, we are, demolishing the front building, the newest building at the facility, and we start peeling back the slab, and we find another slab underneath the current slab, and that was, maybe 6 inches below, and it was pretty hard, and that's probably what the drill rig was getting hung up on. But beneath that second slab, which took a pretty large excavator to get through, was basically a old pit filled with industrial waste going back, 100 years. So the story, changed quickly to demolishing a slab and dealing with 6 inches of soil to dealing with feet of industrial waste. That was an unknown condition that resulted in many delays and, of course, added money and heartache to the developers as well as the previous owners.
It's interesting because yours is one where you did all the right steps, but still found problems that you weren't aware of. And you had made conclusions that were logical under the circumstances. My story is in Massachusetts, and it's different. We had 3 individuals come to us. They were entrepreneurs, and they had started a company, leased space, and had done very well. They kept expanding and expanding and leased more space and more space from the landlord until finally the landlord, looking at them, said, "Would you like to buy?" And they did buy, but did not do any environmental due diligence. So this company kept growing and it became quite a success, so successful that the 3 of them decided to retire. And they were young, and they decided to sell, and they found a buyer for the business. And of course, the buyer wanted the land as well. And when the buyer came back after their phase 1, they said, "We want to investigate a little bit more here." And what they found was a lot of railroad ties, and it appeared to be an old railroad yard. So the sale on the business went through. The sale on the building and land did not go through quickly. It did take time, and it was quite expensive. What I'd like to know from you, Mitch, is tell me what they found you would think they would find in that railroad yard that was buried in the ground.
Typically, when you suspect, rail activity, rail yards, sidings, railroad maintenance yards, or even just tracks, particularly if it's of an older vintage, the first thing that comes to mind are PCBs, or polychlorinated biphenyls. And that's the first thing that comes to mind because they're so highly regulated, which means they're very expensive to deal with. And we may talk a little bit more about those later, but that's the first thing I want to know about is PCBs, whenever I see a rail yard. Then probably the next thing that comes to mind is fuel oil. Most locomotives are diesel powered or some sort of liquid fuel. And they hold a lot of fuel, and fueling practices in the old days probably weren't as good as they were today. So under many rail yards, you find a huge volume of liquid oil, what we refer to as often as separate phase hydrocarbons or light non-aqueous phase liquids, especially essentially a pool of oil underneath the property that, while it may not be as scary as PCBs from a regulatory standpoint, it takes a lot of effort to assess, investigate, and then ultimately clean it up. And of course, railroad yards have railroad ties, the wood that goes between the rails, and they're often treated wood. So they have all sorts of metals in it, arsenic and copper and all sorts of things that you would have to deal with.
Yeah, and also cleaners that they use in solvents and a variety of different chemicals. I think they also found arsenic here. But one pause I would make is that as a real estate attorney, environmental due diligence is part of due diligence in general. And we have lenders in the audience, we have insurers, we have players, real estate players, developers, and lawyers. Some of them environmental lawyers are in the audience. And what happens is that when you do due diligence for a refinance, a sale, often for a fiduciary in a variety of capacities, environmental due diligence comes up, and then the question becomes, when it goes through a phase one and raises questions as it did in the rail yard, and you want to do a phase two, usually the purchase and sale agreement will address how they go about it, and if the seller wants to limit what they're doing, because they still own the property, they want to control the site and control the information flow. And if there's a disclosure to be made to the government or required to be made, they want to head that process. But they also want to know why you're boring holes in their property and where, and what gave you the indication that you need to do it. Mitch, let's move on generally to, I mentioned phase one and phase two. And for some in our audience, I'd like you to talk about it, particularly in light of the fact that phase one standards may be changing. Please discuss that as well.
Sure. Yeah. Often people think of them as one thing, but they really are two completely different products, if you will. Yeah, a phase one, which is, as the name implies, the first step in environmental due diligence, is a paper study. There are no samples collected and is based on essentially the history and interviews of people knowledgeable about the site. We dig into databases of all sorts, environmental databases, government databases. We look at business records. We look at historic aerial photographs, historic maps, what so-called Sanborn maps, which are fire insurance maps. All pieces of information that will help us piece together what happened at this property or what may have happened at this property. And from there, we can make form educated opinions if there are what is known as recognized environmental conditions, which are basically defined as something that would have released or been a threat of release of a hazardous substance to the soil or groundwater at the site, or sometimes to the air. If we do find RECs or recognized environmental conditions, that's where phase two comes in. And depending upon the seriousness of these RECs, additional investigation is warranted, and that's where the phase two comes in. And in phase two is where we would go out and collect groundwater samples, soil samples, maybe even wipe samples of building materials to determine if this REC is indeed something that needs to be considered by the potential purchaser. Now, phase ones there's a standard that most people follow for phase ones, and that's the ASTM, or what we used to be known as American Society of Testing Materials, now ASTM International, publishes what is known as the 1527 standard, which is what most environmental professionals use to conduct phase ones. And the reason we use that to conduct phase ones is because phase ones need to meet the EPA's all appropriate inquiry standard, AAI, to achieve what is known as innocent purchaser protections or potential purchaser protections. And those tie in, going back to the very beginning, to the big B brownfields. If you meet AAI, you are entitled to those big B protections, either from future liability or as a means to get those grants or tax credits. Now, currently, ASTM International is going through their 8-year review, and sometime in the very near future, maybe within the next month or so, the 2021 version of the phase one standard will be published. Currently, it's being reviewed by EPA to ensure that it's compliant with AAI. And some of you may be familiar with the current standards or what will be in the new standard. But the big highlights is that our committee recognized over the past 8 years that there's a whole gamut of phase ones out there, from low-end provider to gold-plated. Now, some sites don't warrant the gold plates, and some sites that do are getting the, maybe the commodity version. And that was recognized as a problem. And this new version of the standard includes more guidance, better definitions, cleaned up the definitions, if you will. It looks at means of getting the environmental professionals to actually demonstrate more logic in the written reports. So you can go back in a year or two and say, that's why it's a wreck, as opposed to saying, have no idea why it was a wreck. And it includes additional guidance in the form of examples in the appendices and flow charts that would maybe take out a little of the mystery of what is a wreck and what isn't.
Well, it's quite interesting because as you're talking about phase ones evolving and changing and what we're looking at, and environmental law itself changes, and there's things coming up all the time that are causing consternation and problems as to how to address it. We'll specifically go to that with PCs later. But as a real estate attorney, it matters the transaction, but I have due diligence that I do in relation to leases, in relation to purchase, in relation to fiduciary matters. And this story is about leasing and due diligence there. And I should also say that I'm not an environmental attorney. I rely on environmental attorneys as well as people with Mitch's expertise. As I do in many other areas, I look to experts, sometimes with risk factors. I look to insurance advisors. And with tax, I look to tax attorneys within our office and elsewhere. So it's not as if I know everything. It's just that I know enough to know what I need. So this story starts with a client who came to me after they had signed the LOI. That's the letter of intent for leasing space in a downtown existing old building. It's well known. It sits on one of the downtown streets in the financial district of Boston, one of the major streets. And it came to me after the first LOI had been signed. They were going to lease space on a 5th floor, and they were moving up to the 9th floor. And the LOI that was originally drafted was changed. All they did was put in 9th instead of 5th, same exact terms, because they were leasing the entire floor. So with my clients, I basically think of it as a team approach, and I say somebody on your team needs to read it. And in fact, the principal decided he's going to read the lease. He said, I'm not a leasing attorney. I said, I just want you to look at it, and whatever strikes you, please do from the beginning to the end. Just on the letter of intent, let's start there. And similarly with the broker who's a member of the team. So Bill came back and said to me, I don't know if this is a valuable question or not, but we could move right into the 5th floor. We didn't need to do any work. But the 9th floor, it's going to take a lot of work to get that space for us to move in. Well, that was worth, quite frankly, about $750,000, that question, because the landlord then picked up the tab to make it an equivalent deal. But he took up the tab as a tenant improvement allowance. And so what happened is we negotiated the lease, as happens oftentimes in leases, who takes responsibility for the idea of, if you as a tenant disrupt something that's in compliance with law, who's responsible to pay for it? So in the leases originally drafted by the landlord's attorney, who was quite a good attorney, and she had put that responsibility on tenant. And I said, I'd like to see the environmental report. She said, you sure you want to see the whole report? It's over 2,000 pages. And don't you just want to see the summary? So I said, no, I don't think so, but let me check with my environmental attorney, which I did. And they said, let's see the whole report. She said, okay, I'll hand deliver it tomorrow. And when we looked at it, that is when my environmental attorney looked at it, the lease summary said there were no problems with this building. But since we were doing improvements to the building, that is to our floor, and taking out walls and doing a variety of other work behind the walls, we learned that there were PCBs. And that created a problem and shifted the responsibility to landlord to clear up the environmental issues related to PCBs in the building rather than the tenant. And other things shifted as well. But I want to ask you, how common is it, Mitch, to find PCBs in a building, and where might you find it?
Well, PCBs, well, everywhere. PCBs, back in the day, and they were banned in the 70s, was that, yet again, another miracle chemical that was used for a lot of good purposes. And one of them was as additives to common building materials, such as paint or surface coatings, and in window caulking, basically to make them more elastic and more pliable and last longer. And particularly in the older buildings, built prior or renovated prior to the 80s or mid 70s, you're likely to find PCBs in various materials, be it caulking or sealants or paint coatings. And when we look at an older building, when we're doing due diligence, that's something to consider, particularly if you're going to do any sort of modification or demolition. These things are highly regulated, as I mentioned, and when you encounter these, common materials, caulking, that have PCBs added as an additive, it becomes what is referred to as a bulk product, and there's a whole slew of prescriptive steps that you need to follow to sample and deal with them. You can manage them in place if possible with encapsulants. Or you need to remove them, and how you remove them is very important, because you don't want to spread the problem. But there's also reporting requirements, and if they do stay in place, you have ongoing obligations. And that's where that AUL that Eric mentioned before, the activity and use limitation, which often in different states and different localities are referred to as different things, such as deed restrictions or environmental use restrictions or environmental land use restrictions, will include that in there. I mean, they're often used to prevent future residential use, so you can have a less stringent closure standard. But in the case of PCBs that you may want to leave in the building, if you encapsulate, or even asbestos, the AUL or deed restriction will include requirements for a monitoring and maintenance and notification. Where do you put the signs? Who do you tell? How do you make sure the maintenance crews innocently don't disturb it and cause a bigger problem? So AULs, circling back to the beginning, have a lot of different purposes, not just the ability to clean up to a less strict standard. But in the case where PCBs are discovered inside and it rolls down to the previous owner or the landlord, it provides knowledge and an understanding of what their ongoing obligations would be.
You know, Mitch, I wanted to ask you, because we discussed the fact that environmental laws are changing and it creates some ambiguous problems for all the parties here as part of our audience. One of them is everywhere chemicals. And could you discuss that briefly, because it is causing concern on both, particularly on just households, but it's also causing some concern. Is there going to be commercial implications from these everywhere?
Well, everyone wants to hear about PFAS, and now how do you deal with PFAS and PFAW in the due diligence or real estate transactions? You know, briefly, and things are literally changing by the day on these chemicals. You know, perfluoride, alkali substances. I mean, they go by many names, and now there's Gen X, which are the latest version of these chemicals, which, you know, as of today aren't considered toxic, whatever, color that any way you like. But these compounds are, once again, these miracle chemicals that were produced to have an important purpose, and in this case, water repellency and a non-stick. And so you find them in everywhere. I mean, they're in Teflon, or they used to be in Teflon, Gore-Tex, all sort of waterproofing, all sorts of metal coating. And the more we look for them, the more we find them. They're ubiquitous. So, you know, people throw out Teflon and Gore-Tex and put them in landfills, and they leach out of landfills. They come out of stacks, and they're airborne deposition. So it's everywhere. So from a due diligence perspective, I mentioned AAI earlier, and AAI, once again, is tied to Superfund. You know, everything cascades, and Superfund regulates what is known as hazardous substances, and Superfund law has a list of all these chemicals or compounds that are hazardous substances. Well, when there's a new compound that's identified as potentially hazardous, it hasn't reached that designation yet, and they refer to them as emerging contaminants. And it's not just PFAS. Another current one is 1,4-dioxane, which is associated with solvents. And currently, I was just reading this morning. EPA published last week their strategic roadmap or strategy document for PFAS, and it looks like these compounds are going to be listed as hazardous substances sometime in 2023. Now, phase ones don't consider chemicals that are not hazardous substances. If it's not a hazardous substance, it can't be a rec. But phase ones do have what is known as non-scope consideration. So you can include PFAS and other emerging contaminants as a non-scope consideration. And that's just what we're doing now. We have several recent phase one and phase two projects where we identified PFAS as an issue, and we've actually gone back and sampled. And in one case, current case of mine, we found it, and now we're working with the seller and buyer trying to figure out the next steps. So when you look at a phase one, particularly going forward, you know, you have to talk to your environmental professional and make sure what he's including, because if he's just saying, I will do a phase one, you know, the scope of work may not include these new emerging contaminants or forever contaminants. You need to discuss that as part of the scope. And then you need to have an understanding how it will be included in the scope. It's moving so fast, and you have to have knowledgeable people working for you, both on the environmental professional side as well as the the legal counsel side. How you create the contract to deal with the emerging contaminants, which may be reopeners in the future, it will be very important.
You know, it's interesting. If we take a bird's eye view of the overall situation, there was a divide before COVID-19, before the pandemic hit, and it became accelerated afterwards. And you can see it in various areas of the country. And that is, older buildings have a variety of problems with them, and it's hard to make them work oftentimes. And you will see Amazon and other companies that are well-heeled going for new buildings, new construction, having it built to spec. And yet the older buildings, to make them retrofitted to meet the needs, whether it be, issues that we're talking about environmentally or other needs, healthy building standards came to the forefront, which are not really part of our topic, as well as whether it's a smart building, whether it has a fiber optic backbone. So these types of issues that we're looking at are part of that puzzle on deciding as a tenant or as a buyer, where you're going to move. Are you going to build buildings? Who are you building it for? Where's it location? It used to be location, location, location. It's changed. That's become one of many standards that we look at. And as to the issue that we came across in the building that occurred downtown in the financial district, another building that we had asbestos floor tiles and ceiling tiles. The question is, who's responsible if you go to disturb? It's in compliance with the law now, but if it becomes airborne, you have to remediate it if you're going to remove it. Mitch, I thought that we might move on to what's coming at you from your neighbor. And let me just, this story Mitch has told me, and what's interesting about it is it occurs in the Seaport area of Boston, which is one of the, it's where Vertex has their headquarters, if you know that. And at one time during the Great Recession, it was one of two sites in the country that was considered being developed. There was a lot of construction that had stopped throughout the country, but the Seaport was the area where a lot of people were thinking of moving. It had been tried to be developed forever, and it's one of the largest plots of land in a city, in a proper area of a city that had not been developed. And what made it very valuable land and attractive to people was that it was 5 minutes from the airport. So with that being said, part of that district is the Fort Point Channel, and that's where Mitch's story takes up. So Mitch?
Yeah, this was another, this was a good one from a couple of different perspectives. We were representing let's say a large conglomerate type organization that was looking to relocate into this very desirable area on leased land. They were going to build a building on land that they were not purchasing. And, this was an old industrial area of the city. So there was a lot during the due diligence we pretty much knew, or at least the client had an expectation what they were going to find. The urban fill, that was a given. There were plenty of old USTs that were removed and leaked. So there's plenty of, petroleum contaminated. So nothing unusual, nothing hard to deal with, all part of, expectations when you're working in an old city. This property was also immediately adjacent, contiguous, shared a property line with, another site that had similar problems and well documented and went through cleanup. So that was part of the expected due diligence. But when we, did our historical research of the area, we identified another site a little down the road, across the street, if you will, that had an active solvent plume. They spilled solvents, nothing terribly unusual, and they had a groundwater cleanup operation going on. They actually, had pumps that were pulling it out and cleaning it up. And we dug in, did the historical research, and looked at all the available reports for that site as well. And we found a series of maps that depicted the groundwater plume, the contaminated shape of the shape of the contamination and where it was going. And they drew this plume right up to their property line, which is essentially the road, and didn't extend it. And they most likely didn't extend it because they didn't put any wells in across the street on other people's property. But if you take the 10,000 view look, that end of the plume was pointing right at this property that we were investigating. So the conclusion is pretty obvious that there may be solvents under this property that are currently unknown. And we advised, our client of that. So it's an obvious recognized condition. And we went into discussions on how they could mitigate it. It's someone else's problem that they weren't going to clean up, and they were not going to spend a lot of money looking for it, but they needed to protect their tenants. So working with the architects and the construction folks, we recommended, putting in some sort of barrier, sort of as a what if there really was. We wanted to make sure there was protection as they were building the building and no need to retrofit. So they ended up putting in, a coating as they were putting in the foundation, and the coating is it goes by there are many different brands. One that most people are familiar with is Liquid Boot, very similar to, the liquid spray on waterproofing. A lot of people put on their home foundations just to keep the water from seeping in. The other interesting thing here, I think I mentioned, is this was going to be a high-rise building, and high-rise is going to have elevators. And these elevators were designed with pits that would be below the lowest level of the building. And, if you think of an elevator car riding up and down the shaft, it's essentially it works like a hypodermic needle. So every time the car goes up, it creates a vacuum, and it can actually suck up, if you will, subsurface vapors. And we went into discussions with the designers and the architects that, this really needs an extra level of protection. So we made sure, and we reviewed the design, that, the Liquid Boot not only was on the flat slab, but also worked its way around the elevator pits and all the penetrations that elevator pits would require.
It's interesting because, first, Mitch, there's, besides Liquid Boot, I understand there's vending systems, but you got to be careful when you use those with PCs. Could you talk a little bit about that briefly?
Well, yeah, I mean, these are for any volatile chemicals, not just solvents. Could be for petroleum and a whole slew of others. But, if you need to retrofit, and sometimes you design this in, particularly on active sites where you are the responsible party, you would put in an active ventilation system, basically perforated pipes or series of pipes below the slab, and you put a pump on it, and you suck out the vapors and you discharge them, either untreated if allowed by regulation, or treated if the concentrations are high enough, at some elevation above where people breathe. And, one of the tricky things, you want to make sure that discharge isn't by one of the air inlets to the building. That's always something you have to look out for. If you put it by the HVA system, you're just you're putting it right back in the building. So you got to be careful about that. And these things you can think of as just glorified radon systems. They're not very complicated. They're relatively inexpensive depending upon the design of the building and the scale. But we often retrofit existing buildings with them, where we discover vapors, a plume of groundwater contamination that gives off vapors has migrated from, or to in this case. And that brings up another quick example, a very current example. Also, on the outskirts of an old city where it was an old industrial area, and we had a client, once again, moving in, eyes wide open, sophisticated client, so they knew, they're buying something with warts, and they're urban fill, the usual, once again, underground storage tank issues, fuel oils. This one was also located adjacent, shared property line with a very well-known facility dating back to World War II, where they made all sorts of defense items, contaminated, cleaned up, had AULs on it that restricted use. And, there was a possibility that this property would be affected by that. But when we were doing the historic research, we didn't have blinders on just to these known issues. We took a much broader look, and we found, going in the other direction from the site, there was a property that had what is known as a down gradient property status on it. Basically, they were an innocent property that discovered a plume of solvents had migrated from yet another property under that property. So, of course, the raises the hair on your neck and says, well, if it migrated, from property A onto property B, which is next to my property, maybe it migrated onto my property. So we researched that original property, which was 3 properties away, and found out it had a solvent plume, wasn't really addressed properly, or at least to current standards. And, it kind of went dormant. A lot of these old sites, people just kind of go bankrupt and walk away. And so we recommended a phase 2 to our client. Let's do some simple vapor sampling to see if it migrated under that adjacent property under our property. And we did find it. It did migrate all that way. So one of the options that we are looking at, if this deal goes through, is that they're going to get a down gradient property status, which is essentially a formalized recognition by the regulatory agency that we have something on our property which is actionable, but it's not our responsibility. We didn't do it. And we know who did do it. And here's the proof. The new owner, or the potential new owner, does have an obligation to protect their tenants or their employees, but they don't have an obligation to clean it up. And this also is a nice segue back into the ASTM updates. This was recognized as a shortfall in a lot of phase 1s that were done in the past eight years, where the historic research wasn't broad enough or thorough enough. So the new standard is including more guidance and a requirement to do more historical research to find situations just like this. If you didn't look, 2 or 3 properties out, this current property may not have, property owner would have known that they were purchasing a property with hazardous vapors beneath it.
It's interesting when we talk about PCs, and we also talk about changing laws. In Massachusetts, it became a nightmare scenario a while ago, and I think you remember this, Mitch, that properties had changed hands under a state standard of PCs that says this level is safe. But then they re-looked at it afterwards and said, nope, it's got to be smaller than that. So now you've had property transferred that required remediation afterwards. And that was very difficult for lenders and borrowers and was problematic. And the way it works, those issues work into leases is very interesting, this idea of changes in law. And that is with tenants and landlords, if you have operating expenses, whether over a base year or not, the question is, I'm on both sides, landlords and tenant sides. On landlord side, anything that comes up that's you want to throw in as much as you can under operating expenses, so tenant shares the cost. And in fact, if it's 100% occupied, they pay for it. And the question is, what should they pay for? And it oftentimes dances around the theory of, is it a new law? Is it something new that occurred that changed something that was compliant to being non-compliant? Mitch, we're at near the end of it. We're on the home stretch. And I did want to have you talk about one more issue that is kind of not behind the walls, but this one is in the walls. And I think that this is a very interesting story of sleuthing to find out what the problem was and where it came from.
Sure. I'll jump right into it. I just wanted to make one fine point to something you just mentioned about, having, the resources if something becomes out of compliance, if it was in compliance. We often refer to those as reopeners. You could have a site that's completely closed, and if there's a new standard that evolves because the toxicological information gets renewed and we find out something's more dangerous than it really was thought to be, or once again, the emerging contaminants may require work in the future, even at a closed site, that those need to be considered. Particularly when access agreements are written, is there access to go back? What are the requirements on either side of the deal? And we talked about emerging contaminants not being hazardous substances and not included in standard phase ones. Well, the new standard will re-emphasize the need for that non-scope work, particularly for things like PFAS, and PFAS will be mentioned by name. And, we don't have a lot of time to go. We don't have a lot of time to go into it, but, a shameless plug here. I just recently published an update on what will be in the ASTM revision. And that was published in Law 360, and we can provide copies or links to it. Just put it in the chat or send Tanya an email. But getting back to that example about a spill that may not be where you actually thought it was. This was an example of a project where no due diligence was done. It was a great deal. They couldn't wait. They just jumped on it. And it was for an outbuilding on, your standard strip mall type property. So this eventual client was buying a building in a parking lot. And when they were doing renovations of the building, they were going to convert it into some sort of fast food restaurant. They found a monitoring line underneath, some flooring. And they went back to the landlord and the people they bought it from. It was the classic see no evil, hear no evil, speak no evil. They said, we don't know anything about this, and you own it, so best of luck. And that's where we got involved, because they realized that there might be some environmental issue out here. And we did our historical research, as you do in any first step, and we found out it was a dry cleaner. And they didn't know they bought a dry cleaner, and and so we started looking for solvents in the ground. And we found it. So there was some sort of release. And then we went to the next logical step, and we found that there was solvents in the indoor air that needed to be addressed. But during the investigation, we didn't see the concentrations in the ground that would lead to the concentrations that was detected in the air inside the building. And we eventually discovered that it was actually coming from the building materials. They did spill, PC, dry cleaning solvent, not only outside in a minimal way, which didn't really cause a too big a problem, but they did spill it in the concrete. And the concrete, which is a porous material, soaked it up like a sponge, and it was off-gassing. So the remedy there was to have to remove certain pieces of concrete and coat the rest of it to prevent those vapors from migrating into the breathing area. So it's sort of like a liquid boot situation, but it's on top of the concrete instead of more traditionally underneath it. So it could be anywhere. So your due diligence can lead you to things you might not expect, but a thorough due diligence by someone with some experience might help. Well, they certainly should have done the due diligence before they bought it, so they may not have bought it, but after the fact, there was a relatively simple solution.
So it's interesting. As I mentioned, I'm a real estate attorney, so it's parties who want to do a deal. And there's a variety of ways to make the deal happen when there are environmental problems, and there's environmental insurance. There's also indemnities. There's also holdbacks. There's a mattering on the size of the deal. But those considerations need to be known up front. And so the environmental due diligence is critical to seeing what you're talking about at various stages and whose responsibility and who's going to take it. Because sometimes you may know an environmental issue, but the buyer may take it on. And as I mentioned, there are people who are in the business of turning brownfields into valuable assets. I think that we're now nearing the question answer stage, but I did want to ask you, or actually, as I mentioned at the outset, we're on the eve of Halloween. And Mitch, you had a way of kind of wrapping this up as a way to compare what happens at Halloween to a child to environmental issues. If you could share that with us.
Sure. When I was thinking about the Halloween theme and tricks or treats, and knowing that Eric is a chocolate aficionado, it all rolls into imagine you're the kid doing your trick-or-treating run, and you go up to this house that maybe kids are afraid of, and they don't usually hang out. They may not have kids, but they're known to be really generous. They got big buckets of candy, and you don't want to spend a lot of time there because it's a scary house, but you do want that candy. So you shove your hand into that basket of candy, and you pull out the biggest one, or the one that looks like it's the best candy you've never seen before, but you definitely want it. And you take it home, and then you unwrap it, and you discover that, maybe it's a, dry apricot, or an apple, or even worse, an apple with razors. So, it looks good, but you didn't do your due diligence. You knew it was the scary house, and maybe, your folks told you to stay away from it, but you knew they were pretty generous with their treats. But, when you open it up, you discovered something you really didn't want, or you didn't know how to deal with. So there's the temptation to, grab something quickly and then figure it out later. Or maybe the smarter course of action is to, do some due diligence, or look at your neighborhood and figure out where's the best place to go.
Well, Mitch, it's been a pleasure being on this journey with you to find out unknown unknowns and tricks or treats on environmental due diligence. Tanya, do we have any questions that the audience has?
Yes, definitely. And yeah, this was a great discussion. I'm going to give a couple of questions that was just submitted during the actual panel, and then we did have some people submit some questions through registration. The first question, and this is directed right to Mitch, do you include recommendations on phase ones, and does ASTM require you to do so?
ASTM, the standard does not require the phase one report to include recommendations. And from my practice is always to discuss my recommendations with the client, and perhaps keep them in a separate document. Phase ones tend to get shared and passed around and reused quite often, and people may lose control of them. And there may be a very good reason why the recommendations were not adopted, and that may not be captured in the historical documents. So I think it's a best practice to do recommendations outside of the actual phase one report, and the actual standard doesn't require that. But discussing the implications of the recs with your client and what would be prudent next steps is always what a good consultant would do.
Thanks, Mitch. Another question. When dealing with off-site properties and migrating groundwater plumes, when would you recommend conducting groundwater sampling versus soil gas sampling?
This is where the subtleties of the context of the situation come in. If we know that the groundwater contamination is a volatile chemical, particularly one that has compounds in it with very low or stringent indoor air standards, that may lead you to go right to a soil gas survey. Now, soil gas surveys are generally less expensive than groundwater sampling. But on the other hand, if you had a property that you're looking at that's in a drinking water or an aquifer protection area, or if you're looking to put in a drinking water or any sort of water supply, well, then you may want to go directly to a groundwater sample. And there's a whole series of ways of collecting groundwater samples, but every situation is different. But and once again, context is everything. But generally speaking, if we're dealing with TCE, PCE, vinyl chloride, or maybe even benzene from a gasoline spill, a quick vapor survey may be the first step, because you can do that outside the building. It's relatively inexpensive, and the access agreements may be less onerous than trying to do something inside the building.
Thanks, Mitch. I'm going to go to a question that was submitted with the registration. Many of the questions that were submitted through registration you already touched upon, but here's one. And Eric, I think this is definitely for you. It's kind of a dual question. So I'm going to just give them both to you at the same time. And it's more of a comment. Special considerations for trust owned real estate and the role of the fiduciary in dealing with environmental issues, as well as real estate in trust banks and non-bank trustees. Could you just touch on that, those two topics?
Sure. As I mentioned before, fiduciaries acquire property in a variety of ways, and there are fiduciary relationships that occur in many transactions. There's fiduciary relationships among partners, and we've looked at this issue and actually our fiduciary, both in fiduciary litigation, which we do in general fiduciary matters, and it is interesting because there are safe harbors when fiduciaries acquire property, but many times fiduciaries end up in situations where there's companies out there. In fact, there's one in the audience that's famous that acquires property. Most of the time, many of the fiduciaries I deal with who are asset managers or dealing with estates of one type or another. They prefer stocks because they say to me, you can't slip and fall on a stock certificate, and there's no environmental issues there, but they do end up with properties. And how do they protect themselves? And I think that although the law does have safe harbors, if you're not actively operating it and you're in certain categories, and there are state laws that vary, but generally there was a case that came out called Phoenix that dealt with this issue because a bank was held liable, and they were very concerned, and it caused changes in legislation because they felt that it was inappropriate to be held liable for an environmental matter. But there are ways that you protect it, and one way that we consider and we look at is you need to have both an exoneration indemnification agreement and defend and hold harmless for the trustee, and have them say you also have to do your due diligence on the way in. That is, when somebody's providing property as part of an estate plan, for example, you need to see the environmental records. And if they don't have it, you need to do it. And particularly on size, we ended up with an estate that had not done the due diligence, and they ended up with property in the south that had a gas station on it that actually did have leaks. So, and in addition, you have to be careful about that exoneration, indemnification, defend and hold harmless provision, because you want it to have a tail on it. By that, I mean, you want it to protect you if you resign as trustee. And you want to be careful as to, how you take title frequently. You don't necessarily want to be taking title as a trustee. You maybe want to have it in a limited liability company, which is what we'd recommend, and then keep some insulation between you and others. But remember, it's the operator and the owner that's in the chain of title. And as I mentioned at the beginning, there are safe harbors, but you still need to be wise on what the law is and how to protect yourself.
Thanks so much, Eric. I just wanted to throw out a comment to both of you. And thank you, Tom, for mentioning this. Tom said, great topic, and thank you for mentioning emerging contaminants. So another question, and Mitch, you kind of touched on this already, and we have a minute left. So any of the questions that we didn't get to, do you two both agree that we can shoot them out an email or reach out to them? I'll have all the questions so I can give that to you both for you to respond. Is that okay with you both?
Sure. If they could reach out to Mitch directly or me directly,
Perfect.
if they want to, it works. Mitch's article is well worth reading.
Yeah, I can provide that with everybody. There's that puppy, right, Eric?
Yeah, that's my puppy who slept through this until now.
He did really well. He did really well.
Just about 2 o'clock.
Not bad, not bad. So Mitch, just somebody had written into the questions revisions to ASTM standards, and I know you touched on that, but maybe you can just wrap up with that.
Well, once again, it's the 8-year cycle is just about up. The current standard 152713 is going to sunset at the end of this year. The draft 1527-21 has been drafted. It's in review by EPA, and it, last I heard very recently, it may be within the month that it'll be published and available. The other thing one last point, 1527-13, even though it sunsets, is still going to be compliant with AAI. AAI has not changed. It's just the standard has been improved and cleaned up. So 1527-13s are still viable, but 21 is in the improved standard. So just when you're purchasing them, so to speak, make sure you know which one you're purchasing, because 21 is going to be a little longer, a little more detailed.
I just wanted to express a thank you to Tanya, and thank you to Mitch, and thank you to our audience for taking time out of their busy day to listen to us. So much appreciate your attendance. And
Yes, and-
again, if you have any follow-up questions, just get in touch with Mitch or me.
Sure. And thank you both. Thank you, Eric and Mitch. This was really an insightful panel discussion, and we greatly appreciate your time as well. And like Eric said, if anyone has any inquiries regarding this discussion or anything else, you can reach out to me at tbissell, that's TBISSELL. You'll get it in an email at rouxinc.com, and I'll be happy to connect you together with Eric or Mitch, or if I can help anybody out or forward them the article, whatever you'd like. So again, on behalf of Bernkopf, Goodman, and Roux, we thank you for your time, and everybody have a great rest of the day. Thanks, guys.
And a happy Halloween.
Absolutely. Happy Halloween. Be careful of that candy bowl.